more than 50 people have joined us, and they will be joining as the session will be moving forward.
No problem. Surely.
Okay, sir, so we are live now. So, okay. So greetings to everyone once again after a long time, and I hope everyone is doing just well with their health. So welcome everyone to today's brand new session on the topic Supreme Court Practice and Procedure. And we have Mr. Samiron sir with us here today. And trust me when I say that no other person will be a better speaker on this topic than him. So without much ado, let me introduce sir to one and all present over here on YouTube Live with us. Mr. Samiron sir is currently the partner of Desai and Diwanji, and he was previously the partner in IGA for a period of long 7 years. And after completing his LLB from the faculty of Delhi, he went on to have his LLM from the University of Aberdeen in International Commercial Law. Sir is an advocate on record of the Supreme Court, whose expertise revolves around all the matters pertaining to dispute resolution. And apart from that, let me tell all of you that he is one of the most humble person I have ever talked to. So, sir, it's an honor to have you here, and I will be much obliged if you'll take her from now, sir. Over to you.
Thanks a lot, Hemant. That was such a lovely introduction that I would not have thought for myself, but thanks a lot. And thank you everyone, firstly, for making time to attend this webinar on practice and procedure in the Supreme Court. I mean, the topic really sounds a little draggy, boring, sunne mein lagega zarur, lekin, but I'll try my best to make it as interesting, as possible. Actually, when Hemant first contacted me and asked me to speak on something, I thought I'd speak on some topic on a substantive provision of law, maybe, shayad contract law or labor laws. But then I thought, during this entire time since this COVID situation started, all of you must have been attending a lot of webinars, and a lot of people must have already spoken on that topic. So I thought I'll speak on some procedural aspect, because that is also a very important facet of law. In the sense, basically, if you have a client and he comes to you to file a certain case for him, and you are very well aware of the substantive provision of law, but procedure aapko nahi malum, to that becomes a big problem. That can demolish your case tomorrow, and therefore it's a very important that you equally have a very proper knowledge about the procedure surrounding filings, etc. Now, why Supreme Court? Because, I think the viewers, mostly all of us, will be from different parts of the country. So there are different courts everywhere, I know, and the procedure will be different for everyone. But there's one connecting factor for us, that is the Supreme Court. So therefore, I have chosen the practice and procedure before the Supreme Court. So I will be actually speaking on 4 essential topics today, which is basically the fundamental. Fundamental would include the basis from where the Supreme Court actually derives its power, 1. Number 2, we will discuss the different types of jurisdiction. Now, when we say jurisdiction, this is not territorial jurisdiction, of course, because this is the Supreme Court of India. We are talking about subject matter jurisdiction. किस प्रकार के cases Supreme Court में आप institute कर सकते हो, file कर सकते हो. The appellate jurisdiction जैसे है उनका, yeah, there's also an original jurisdiction that the Supreme Court possesses. We'll come to that. And then I'll talk to you about within the appellate domain, the most famous jurisdiction that the Supreme Court has, that's the special leave jurisdiction, basically the extraordinary appellate jurisdiction, under which we file what we call as very famously the special leave petitions. And lastly, there'll be a lot of you who will pass and you're going to become lawyers very soon. You might want to know about the different, the procedure that the Supreme Court has now come out with for filing during these times when we're having virtual hearings, etc. Is dauran aap kaise file kar sakte ho court mein, and all those kind of things. I'll touch a bit about that also, so that by the time you go back home, you have some academic and also some practical sort of knowledge about how we can go about the practice at this particular time. So yeah, so starting with the fundamentals, basically the provisions from where the court derives its powers. This is a quick run on certain provisions of law that I will like to go through with you to let you know about that. Uh, Starting with Article 124, 1 of the Constitution of India. So the Supreme Court has been constituted under Article 124, 1 of the Constitution. Originally, it had 8 judges, and from time to time, the Parliament has increased its strength. Today, we are at 34 judges. Then we have Article 129 of the Constitution of India. This article provides that the Supreme Court shall be a court of record and that it can file for its contempt. Now, for its contempt. Punishing for contempt, I'm sure all of you will be aware of, because I mean, it's very, as mildly put, if you misbehave in front of the court or you do not follow the directions of the court, then you are liable, to be punished for contempt. But what is this thing that being a court of record means? Being a court of record actually means that the judgments or the records of the court have an evidentiary value and they cannot be called to question by any other court. What does this mean? It means that basically the judgment of the Supreme Court would stand to be the law of the land and it cannot be questioned. That's why probably whenever you have had your internships, etc., whenever you have a research proposition to deal with, your seniors or your mentors will ask you, get me some judgment, and they'll say, Supreme Court. Huh? So they'll tell you that because that's where the buck stops, and that is why it's a court of record. Then the next article, which is another big source of power for the Supreme Court, is Article 141. This article we also sometimes refer to as judge-made laws. So any judicial pronouncement by the Supreme Court is the law of the land, basically. So, and it's binding on all the courts in the territory of India. After this article, we have the Supreme Court Rules 2013. So the entire practice and procedure in the Supreme Court, which is there, this is under the Supreme Court Rules of 2013. सारा कुछ मतलब practice के लिए आप क्या filing कहाँ क्या करना है, आपको court fees कितना देना है, defects कैसे clear करते हैं आप वगैरह इत्यादि, जितना भी आपको practice के लिए जानना है, everything is there in the Supreme Court Rules 2013. Before this, we had the 1966 rules, and before that, originally we had the 1950 rules. This 1966 rules actually went for an amendment 39 odd times. So therefore, finally, we came up with the 2013 rules, which are in effect from August 2014. Finally, another provision of law, which is again from where the court derives its powers, is Article 145 of the Constitution. This is the very article basis which the Supreme Court makes its procedural rules. This Supreme Court Rules 2013, which I just spoke of, is actually enacted basis the power that is with the court under Article 145. So this was briefly to introduce to all our viewers basically the main powers of, the background powers from where, if I may put it that way, from where the court derives its functional abilities. So moving on to the next topic that we have, that is, I'd like to take you through the different jurisdictions that the Supreme Court has. 3 types basically. एक है Supreme Court के पास the most popular jurisdiction, that's the Appellate Jurisdiction. You would know this कि ज़्यादातर हम जो Supreme Court में cases file करते हैं, that is mostly appeals. High Court से या कोई Appellate Tribunal से हो, और आपका मतलब जो भी orders आप impugn या challenge करना चाहते हैं, so you file an appeal against such orders before the Supreme Court. So that is its major jurisdiction. The Supreme Court also has an original jurisdiction. So an original jurisdiction, a lot of law students will know. Some of you may not know also. When I was in my first years, probably because I did the 3-year law course, etc. These were all novel terms to me when I started. So just for everyone's benefit, I'll say the original jurisdiction basically is basically the powers of a court of first instance to try a suit or a petition at the very first level of it all. So the Supreme Court, despite otherwise being a court of appeal, also has a very important original jurisdiction. We'll come to that as we go about the explanation. And thirdly, the Supreme Court has an inherent jurisdiction. So as the name suggests, inherent. So matlab this is something which it inherently possesses. And the inherent jurisdiction is actually used for a larger, to satisfy a larger judicial conscience, if I may say, to make, to basically have the ends of justice, if I may put it in a, with legal expressions, if I say. So that is when it uses its inherent jurisdictions. It ordinarily has the powers of review, curative, which we will also discuss about, and powers under Article 142 to do conscionable justice, as they say that under that article. So this is what the Supreme Court has inherent jurisdiction for. So before, we go down to all that, we'll first deal with the appellate jurisdiction, the different types of appellate jurisdiction that the Supreme Court has. Three basic types. One is appeals under certificate, number one. Number two, statutory appeals. And number three, the special leave to appeal, which is the special leave petition, which is also our highlight for today, which we will deal elaborately. But to give you a flavor of the other two first, appeals under certificate are such. These are filed basically on the basis of a certificate from the High Court is provided under Article 132, 133, and 134 of the Constitution, both with civil and then later under 130 and 134 on the criminal side of it all. So basically, when a matter is dismissed by the High Court and a party is aggrieved, applies for this certificate, then the High Court, if it thinks that there is some substantial question of law, so it's a very funny situation if I put it that way. The High Court has dismissed the appeal or what the case that was filed before it, but it still feels that there may be a substantial question of law involved. So it gives that aggrieved party a certificate to go and appeal before the Supreme Court. Be that as it may. So that is how it works. One thing to remember is that the Supreme Court, I'm just telling it to you now itself because there will be some discussion on it later. The Supreme Court is mostly concerned with a question of law. Facts are not something it is often bothered about because facts are something that you take care of in your trial cause or maybe the first appeal. Not that you can't bring about new facts in the Supreme Court, but it is a situation that can be done only with permission of the court. So that is one thing. So therefore, the certificate that's provided is often only in relation to substantial questions of law. But as time has evolved, what has happened is that this practice of issuing certificates that has become almost negligible. Almost all appeals are filed under Article 136, जो आपका special leave petition है, ज़्यादातर, for the purpose of the fact, it's simply because of the fact that no one goes to seek a certificate anymore when such a wide power is already conferred through Article 136. Of course, if it's a statutory appeal, that's different. Then you don't go to 136. So statutory appeal is the second type of appeal. So what is statutory appeal? A statutory appeal is something for which the appeal provision is already provided in the statute book. In the sense, you don't have to file an SLP for that. For example, a lot of you will be knowing about the Insolvency and Bankruptcy Code. It's been in vogue for the last 2 years, like anything. So you also, most of you will be knowing about the NCLAT. Now, for example, the NCLAT passes some sort of an order or judgment. Now you want to appeal against it. You do not file an SLP for that. You have a provision therein already, Section 62 of the IBC. So what happens when you file such an appeal is that it is already registered as a civil appeal. And similar to what I talked about a little while ago in relation to the appeals and the certificate, all these sort of appeals, when you file before the Supreme Court, they are already registered as civil appeals. If it's a criminal appeal, that's fine. It's already registered as a criminal appeal. So this is second. So what we just talked about, the second sort of appeals was the statutory appeals. So one example was IBC. You have also the Consumer Protection Act. So an appeal from the National Consumer Disputes Forum will also directly go to the Supreme Court as a civil appeal. फिर आपका इलेक्ट्रिसिटी एक्ट है, उसमें आपका सेक्शन 125 है, जिसके तहत आप डायरेक्टली सुप्रीम कोर्ट में अपील फाइल कर सकते हैं फ्रॉम एनी जजमेंट ऑफ द एपीलेट ट्रिब्यूनल. एंड देयर many such, I mean, good about a lot of statutes which directly provide people, some of you guys who may be doing trainings with typical corporate firms जो SEBI, securities laws, etc. Practice करते हैं. So you see there that for even the SAT tribunal, when against its order, you can go directly to Supreme Court. So these are these examples that you have of the statutory appeals. And the last type of appeal, again, we fall back is on the special leave petition. So this special league petition, of course, is the most popular one now. Like I was mentioning, it is separately now termed as the extraordinary appellate jurisdiction of the Supreme Court because of the sort of powers that you have. The not powers. I mean the liberty that you have, or and the discretion that the Supreme Court has under that jurisdiction of an SLP. But like I was telling you, how a statutory appeal is registered as a civil appeal already, or a certificate appeal is already registered as a civil appeal or a criminal appeal. And SLP, you have to remember, we'll talk about it in detail again, is not an appeal already. It's not registered as an appeal already. It's merely a leave that you are seeking from the court to appeal. Leave to appeal का क्या मतलब है? Don't go about it very literally. I'm sure a lot of you are wise and already know it. But for people uh, who are average students like me, leave to appeal is nothing but permission to file an appeal. So, in your course of your journey, as long as you'll often come across this expression, I'm craving leave to do this, I'm craving leave to rely on my this particular submission, this and that. So, it's nothing but seeking permission. So, an SLP is nothing but special, permission to, you're seeking a special permission to file an appeal. And if the Supreme Court thinks fit, तब वो आपको वो permission देंगे और जिसके कारण से आपका जो अपील है वो कन्वर्ट हो जाएगा, स्पेशल लीव पिटिशन जो कन्वर्ट हो जाएगा सिविल अपील या क्रिमिनल अपील जैसे, मतलब whatever was the SLP you filed accordingly. So these are the three basic appeals. The certificate appeals, the appeals on the certificates under Article 132, 133, 134. Then you have the statutory appeals. That is the appeals which are basis provisions already provided under some act, and the special leave petition. So, coming to the next jurisdiction that the Supreme Court has is the original jurisdiction. Now, broadly, there are five types of original jurisdiction that the Supreme Court possesses. These are original suits. Yes, the Supreme Court also hears suits, and these are very specific sort of suits, जो हम आपको बताएंगे. Then we have petitions under Article 32 of the Constitution. Then we have applications for transfer of cases. Fourthly, we have reference petitions. And fifth is election petitions. So these five types of cases can be directly filed to the Supreme Court. So these are not appeals. So that is why it is an original jurisdiction of the Supreme Court. Now, these suits, firstly, that we file before the Supreme Court are under Article 131 of the Constitution. So these are suits between the government and one state on one side, maybe, and one or more states on the other side. Between the government of India on one side and all the other states, on the other, or many one or more states on the other side, or between two states also. So, for example, that Kaveri water dispute between the state of Karnataka and Tamil Nadu, a lot of you must have read of this, is an example of an original suit that was contested before the Supreme Court. There are many such examples. I'm just giving you one of, this is a little more famous. So, in a suit situation, the Supreme Court rules itself provides for how a suit is to be conducted. It basically has borrowed all the rules, mostly of the Civil Procedure Code itself, and it's a full-blown trial, like you would do in a trial court. जैसे आप suit अगर institute करें किसी भी trial court में for any suit for possession, I'm just saying, giving an example. So आपने plain file किया, written statement होगा, उसके बाद opposite side का, then you have your production of documents, evidences, etc. Everything is also taken. I mean, conducted in the same manner in the Supreme Court also in all these suits that are filed before it. But of course, the remit of this is very less. It's only those sort of few examples that I just talked about where you can file a suit. Then you have the next example of an original jurisdiction is the petition under Article 32 of the Constitution. These are petitions for issuance of orders, directions, or writs. For what? For enforcement of fundamental rights. So Article 32 is itself a fundamental right, and is a part of the basic structure of the Constitution. So this can be for a lot of things, but mostly Article 32 is filed. You'll all know that you file an Article 32 only against a state or its entities, and it's not a private party dispute, of course. And then Article 32 is often filed when you are wanting to challenge an arbitrary action or something which has infringed a fundamental right in a central level. What I mean is, for example, if the government has come out with a central act which has a bearing, which you feel that sort of infringes your fundamental right of all the people of the country, for that matter. So you may file your petition under Article 32 in the Supreme Court on that account. Sometimes when a subject matter is very state specific, people have come to the Supreme Court under Article 32, but then the Supreme Court often says that since it's a state issue, the High Court of the state is more apt, aptly prepared to deal with it. So then they remand it back. तो आपको फिर Article 226 में जाना पड़ेगा अपने local High Court में for basically again enforcing your fundamental right itself in that High Court. So Article 32 is one such sort of an original jurisdiction before the Supreme Court. Then we have the transfer petitions. So transfer petitions are petitions for transfer of any criminal case or a civil case that is pending before one high court in one state to another high court in another state. You can file. This can be for a lot of reasons. You can also file, an application for transfer of a case in one civil court also. I mean, a trial court also in one state to another state's trial court. There are also transfer petitions in relation to substantial questions of law. For example, if there is a petition which is pending in the Supreme Court, and a similar question of law is pending before some other high court also for some reason, then an application may be filed that all these petitions which are pending before the High Court may be transferred to the Supreme Court. So the Supreme Court, who is already listening to these sort of matters, may hear it together. So one very common example of transfer petitions are, this is just for knowledge because you will come across it, matrimonial disputes. So often, one spouse would often, if they are now living separately in two different states and one party seems to have instituted a matrimonial suit in one state, often the other party, not often, but at least at times, would want that case to be transferred to the jurisdiction where they reside. I mean, to that particular area. So more often than not, I mean, in my experience that I've come across, at least 75% of the cases of transfers are in relation to matrimonial disputes. And so now we have the fourth type of original jurisdiction. This is the reference jurisdiction. Now, this is a bit technical one. What's the reference jurisdiction? It includes a reference by the President of India under Article 143 of the Constitution on a question of law. Now, here the Supreme Court also goes into fact, question of law or fact of public importance. So one example that I'll give you, because it's a famous case of a petition which has been of a reference petition, is a special reference number 1 of 2012. I mean, people who want to take note can do that. Now, this is what we call as a natural resources allocation case. So if you remember, there was this famous 2G judgment, Center for Public Interest Litigation India versus Union of India, 2012 3 SCC 1. So over there, the Supreme Court had actually cancelled 122 2G licenses granting spectrum and had ordered that there should be a reallocation of all these licenses through auction. In the wake of this judgment, what happened was the president then, made a reference to the court asking whether, auction, is it correct? Like what the judgment says, that whether auction is the only correct means for allocating spectrum. The court held in the reference petition, special reference number 1 of 2012, it held that if revenue maximization is an object of policy, then auction would be one of the most preferred methods, but then not the only method. So I'll leave it at that. What it means, you can, sort of find out yourself. There's some fact-finding mission that you must do by reading these two judgments. There are other references. It gets a little technical. I'll skip that for the time being. I'll go to the last of the original jurisdiction that the Supreme Court has. These are your election petitions. So this is a petition under the Presidential and Vice Presidential Elections Act 1952, read with Article 71 of the Constitution. This is in relation to doubts and disputes that may arise, in relation to the election of a president or vice president. Sometimes a candidate who has contested for being the president of India and has lost, they filed presidential for such law. I mean, for such loss in their elections, they have filed election petitions. So that is one. And so with this, we basically come to the end of the original jurisdiction that the Supreme Court possesses. So basically 5 types, just to recapitulate. We have the suits, which we file within the government and the states, or the state and the state, etc. फिर आपके the petitions जो आर्टिकल 32 में आप फाइल कर सकते हो अंडर फॉर एनफोर्समेंट ऑफ फंडामेंटल राइट्स. फिर आपका इलेक्शन पिटिशन आया जो हमने आखिर में बात की, उससे पहले स्पेशल रेफरेंसेस और रेफरेंस पिटिशंस रादर, and also last but not the least are the transfer petitions. So apart from, so this is what the original jurisdiction of the Supreme Court is composed of. Then the Supreme Court has the third type of jurisdiction, which is called the inherent jurisdiction. So, like I was telling you, so inherent means as if it is they are already possessed of this jurisdiction. Why? By virtue of being the Supreme Court, the top court in the country, because it has. I mean, everyone looks at it for the ultimate justice. So, the types of matters that the Supreme Court takes up in its inherent jurisdiction are number one, review, number two, curative, and number three is its jurisdiction under Article 142 of the Constitution. So, what is a review? A review is basically filed once your SLP or your civil criminal appeal, etc., is disposed of. I mean, it's dismissed. So, once it's dismissed, you still have a right to file a review petition. But there are only so many grounds that you can urge. The three grounds, so I'll just let you know what they are. One is discovery of new and important matter or evidence which was not there before. Number two, on account of some mistake or error apparent on the face of the record. So you'll have to demonstrate in your petition that your lordships, when you filed or when you passed this particular order, there a complete mistake has occurred or there's an error apparent on the face. Why? Because you have missed to notice this particular thing at paragraph such and such. I'm just giving an example. So this would be you'll have to demonstrate an error apparent on the face of the record. And thirdly, the third ground for review is for any other sufficient reason. So this is that gateway where you can sort of push in everything. Of course, it can't be very trivial. The Supreme Court will see that yes, it must be something which is very sufficient to allow them to invoke their review jurisdiction. So there are certain important things about review. A review is circulated before the same judges who heard the main petition. Of course, this is a typical facet of review in every court, be it the trial court, be it the high court, or even in the Supreme Court. A review is filed always before the same set of judges, is heard by the same set of judges. Just that in the Supreme Court, a review is disposed of or heard and adjudicated by way of circulation. You don't have oral hearings in a review jurisdiction. They even accept if it's a matter of death reference. You must have heard of this case of Muhammad Arif versus Elias Ashfaq versus the Registrar Supreme Court. Take the citation 2014 9 SCC 737. So the Supreme Court held there that in review petitions arising out of those cases where the death penalty is awarded, it would be necessary to accord oral hearing in the open court. So this is one exception where the Supreme Court allows basically oral hearing in a review petition. The next type of an inherent jurisdiction for for ends of justice, which the Supreme Court has, is the curative jurisdiction, or what we find as curative petitions. These curative petitions is a very homegrown jurisdiction, if I put it that way. It's a jurisprudence which the Supreme Court has developed on its own, and it is not found in the Constitution. And this is basically the Supreme Court has come out with it so that people have something to file and not go to the Supreme Court under Article 32 praying for enforcement of fundamental rights after a review has been disposed of. So if your review also has been disposed of, despite that, if you think that no, the lordships made some mistake, even while disposing of the review, then you are entitled to actually file a curative petition. But there are guidelines for filing a curative petition. This jurisdiction or ambit which the Supreme Court has, the scope was developed actually in a particular case called Rupa Ashok Harra versus Ashok Harra, and the citation for that is 2002 4 SCC 388. So you have to, when you file a curative petition, you will have to completely show and demonstrate that you have followed the guidelines of that. In fact, even in a curative petition, also you do not have oral hearing. It is again by circulation, But in this, in a curative petition, apart from the judges who already dismissed your SLP or civil appeal and then your review, three of the most senior, most judges also sit along with them. And one another very important facet about this is that a curative petition has to be signed by a designated senior counsel of, and to certify that the guidelines as mentioned in the case of Rupa Ashok Hadra has been fulfilled in this petition. So that's one. So this is basically a very important. So the advocate on record who's going to file, it has to be very sure about, what he's doing in when he's filing that petition. To be very sure that all the guidelines are met. There is no improper pleadings. The pleadings are absolutely proper, and the technicalities have been taken care of. So that is the thing about curative petitions. And then the last thing is Article 142 of the Constitution, which is basically if there is a situation where there is, there is no law. I mean, there's a void in that area. There is no law which has been named by the Parliament, etc. The Supreme Court will not be sitting idle in such situations. So it will pass directions, pass laws, and they'll say that it's under Article 142 of the Constitution. For example, before the act in relation to sexual harassment at workplace came about, you must have heard in your law schools, you must have been taught about Visakha versus State of Rajasthan's judgment. So that is one area where the Supreme Court came out with guidelines in relation to protection of women in workplaces. So this is one case of one of the Supreme Court using its inherent powers under Article 142 of the Constitution. So yeah, so with that we come to the end of the different types of jurisdictions. We talked about the appellate jurisdiction, we talked about the original jurisdiction, and lastly we just spoke about the inherent jurisdiction of the Supreme Court. So now going back rather to the appellate jurisdiction's most sought after provision of appeal of filing an appeal is the special leave petition. Why I'm speaking more about it today is because when you come to practice, this will be the area that you'll ordinarily find to be more involved in your Supreme Court matters than statutory appeals, or I would not know about certificate appeals now at all because I haven't come across it till now. So I wouldn't know whether you would, but you would mostly come across special leave petitions. So I thought if I can give you some information about that, it'll be worth it for your practice. Uh, so basically, the major ingredients of what a special leave petition should have is what we will talk next about. So, but before that, a brief introduction basically. So, the Supreme Court has been given this extraordinary jurisdiction under Article 136 of the Constitution. It can grant special leave under this article from any judgment, decree, or order passed by any court. So, this is very important. Basically, even if it's a trial court's order, you have the ability, or the Supreme Court on its own has the power to listen to an appeal directly from that court as well. And I'm very careful in what I'm saying. But the fact is that the practice has slowly changed. I mean, and strategically also as a lawyer, you would not want to go to the Supreme Court directly and take away all the other appeals that are available to you midway. So. That is otherwise the power which I wanted to tell you about. So you can basically file an SLP against any judgment, decree, order of any court before under Article 136. The only limit that is there on 136 is in 136 subclause 2 itself, which says that you cannot file an SLP against the order of an armed forces tribunal. So that's the only limit to it. So one thing which is very important to keep in mind is, like, which I had spoken earlier about, is in relation to the fact that an SLP per se or special leave petition is not an appeal in itself. I'm just reiterating this all the time, but probably you'll understand this in a while. Like, we have the certificate appeals where it's a civil appeal which is registered. We have the statutory appeals which is registered as a civil appeal. But an SLP, civil or criminal, is not already registered as an appeal. It is mere permission to the court. So it's a discretionary relief that you get. So, and it's completely in the discretion of the Supreme Court after reading your SLP and hearing it on a Monday or a Friday when it's listed the miscellaneous days to grant you that permission or not. tell you, I mean, before COVID, BC era, when we Mondays and Fridays we used to have about 100 odd SLPs in the Supreme Court, every court of the court, Supreme Court rather, and it's only 10 to 15%, where notice is issued, and that's the amount, minuscule amount of petitions where leave is granted. I mean, I wouldn't say leave is granted firstly. I mean, notice is issued first, to the other side, and rest everything, good amount, 80% odd is almost dismissed. So yeah, that's how it is. It's a discretionary relief for the Supreme Court has, and they exercise this discretion with a lot of caution. Another thing, before we go to the form and the content of the special leave petition, is I'd also like to inform you about the limitation period in filing an SLP before the Supreme Court. Limitation, like most of you already know, some of you may not know, is basically the time period for you to file the SLP before the court. Limitation is otherwise time period for filing anything before any court. In this case, for the purposes of filing an SLP before the Supreme Court, you have 90 days from the date of the impugned order. There are two exceptions. One is that if somebody had applied for a certificate, from the High Court to file an appeal under Article 132, 133, or 134, and that was refused, then you have only 60 days to file the SLP. Another one is when there's an order of death sentence. For that also, you have only 60 days to file an SLP. So this is about the limitation period to file an SLP. So now we will come to the major contents what an SLP contains. So this is a very standardized draft. You can play around within those essential headings which the form provides. But an SLP otherwise has 8 essential headings. The form basically is form number 28 under the Supreme Court rules, under which you file an SLP, both civil and criminal. And it has 8 essential headings, your special leave petition. One, you have the introduction. This will have basically maximum 2 odd paragraphs. You introduce the order that you are impugning or challenging. You say the petitioner is filing this present special leave petition against the order dated such and such, passed by the Honorable High Court of such and such. That is simply that. And you may have another additional paragraph. The petitioner is aggrieved owing to the fact that, and say just another line or two. But that is where your introduction ends. You cannot give a full-blown, case. You take out your entire case, or sometimes that we do in a writ or in a suit where we want to have a huge synopsis of sorts already in the introductory paragraph. You cannot do that, of course, in the SLP. You have to limit it to maximum of 2 paragraphs. Then second heading is your questions of law. So this is where you assail the judgment of the High Court that you are challenging, on the points of law. यहाँ पे मतलब जो आप मतलब challenge कर रहे हो, this is not on your factual grounds पे आप challenge नहीं कर रहे हो उसको. This is on the point of law that you will challenge. Basically, the law that has already been laid down by the Supreme Court on some provision that if you see that the High Court has done has come out with an interpretation which is in deviation, or which is in distinction or removed from what the Supreme Court has said. So that is what you bring out in these questions of law in the Supreme Court under an SFP. The third heading that you have in the Supreme Court is a declaration. You have to give a declaration that you have not filed any other petition before any other court against the same impugned or same order that you are impugning before the court. You have another declaration followed. That's the fourth heading is another declaration that you have. You have to declare that the copies, the annexes that you are filing in along with your SLP, are true copies of the documents or the pleadings that were part of the record in the court below. So this is to make sure that you are not introducing any new fact or any new document in the Supreme Court under an SLP. You can introduce, but for that you have to file a separate application, for seeking permission to file to bring new fact, to place additional documents on record, application for permission to place certain additional facts. Of course, you'll have to. Good luck with that, because you really have to demonstrate why you couldn't file it earlier before the trial courts or the High Court. But yeah, and it's not an impossible situation. I'm just saying that ordinarily, you of course you generally cannot just simply introduce it. You will have to seek permission for that. Fifth are the grounds. Now, one interesting thing about grounds in an SLP is that grounds may not be purely legal grounds. And this, I'm slightly departing from what I had said earlier. That the Supreme Court is mainly interested in point of law and questions of law. But over course of time, people have been urging factual grounds also to demonstrate that the order of the High Court that they're impugning, uh, they deserve to be actually it actually deserves to be set aside. So factual grounds can be introduced, and there are judgments on this. I really don't want to go through the passage of the judgment, but because this is a statement I'm making, which is a little which people might contest, so you may take down a certain judgment's name, Jamshed Hormus G. Wadia versus Board of Trustees, Port of Mumbai and others, 2004, 3 SCC 214. The relevant paragraph is para 34, Justice Lahoti's judgment. And he talks about, in that particular paragraph, when you read, I'm not reading it out now, but when you see that he has clearly expanded the scope of an SLP beyond substantial questions of law. And he says that practice shows that to meet the ends of justice, the Supreme Court may even go into a question of fact. So, yeah, so the sixth essential heading is the grounds for interim relief. So there'll be a lot of times you may need an interim order also when you file an SLP and the SLP is pending. If you're lucky enough, the Supreme Court really finds merit in your SLP and issues notice. In the meanwhile, for example, it's a suit for possession that you had before the trial court, which you lost in the High Court. Now you've come to the Supreme Court. Yeah, so you might, in the meanwhile, want that the landlord or whatever, does not sell the house in the interim. So you might want an injunction. So the grounds for interim relief, of course, has the same. It has to go through the same test of that is there for any other interim relief. That's your prima facie case, your balance of convenience. That's in that basically the balance of the case should tilt in your favor and not that of your opponent. And irreparable injury, of course, the third ground, which is nothing but mostly that the injury is going to be such that cannot be compensated through monies. So these are the ordinary three tests which you'll have to, of course, demonstrate while asking for, while pleading your grounds for interim relief. And then you have the last two headings, the seventh and the eighth heading, which is nothing but the prayer clauses. These are very standard prayers. You can't really ask much. You have to simply ask for, in the main prayer, that is to allow to admit your, SLP, to permit to grant leave to appeal, and number one, set aside the impugned order. And in your interim relief, you'll ask for again a standard prayer that would be in the line of in the pending the SLP, the court may kindly grant, an injunction or status quo, whatever it is that you are seeking. So yeah, one more thing. So these are the main essential eight headings. But one thing that you also I'd like to inform you is that you also have a synopsis and a short synopsis and a list of dates that accompanies your special leave petition. The list of dates, one thing to remember, it has to be very chronologically arranged. Very chronologically arranged means it has to be chronologically arranged to the T. You can't, even if it spoils your flow of case, sometimes, you want to state your story in a, for example, if you're drafting a suit, sometimes you might state one fact, suppose this thing happened on 1st of June, and then you were saying that on 5th of June this happened. Then after that, you might want to say that, however, in the meanwhile, on 3rd of June, this had already happened. You cannot do this in the list of dates in the Supreme Court. You have to go 1 June, 3 June, 5 June. So, and God forbid you have not arranged your list of dates chronologically. That is the registry's favorite defect to be marked. So you'll have to necessarily cure that defect before the SLP will actually be listed in court for hearing. So with that, then we come to the end of what a special leave petition contains also, and mostly we are done with the academic portion of our discussion today. But before I mean, you may ask me your questions. I just also thought about, because also some of you are on the cusp of becoming lawyers already, and some of you may otherwise want to know the procedure. You are training, etc. Virtual internships, I think, are on vogue now. Uh, we and you might want to play a part in assisting your mentors and seniors in your chambers and firms. So just to give you a flavor of how the Supreme Court is going on right now, the virtual hearings going on day in day out, of course, in the court. Uh, so in relation to such hearings, when this pandemic actually came about, and the Supreme Court also very early on took cognizance of this and realized that it cannot just shut itself in these times and not let people have access to justice. So very conscious of that, they set up a committee team. They put their people in relation to the technical team in place to bring about a methodology to how you would appear, how we can have these hearings going on, and also came out with a standard operating procedure. The first standard operating procedure actually came out in 23rd of March itself, and they've come out with different standard operating procedures over time. And the last one came out on 4th of July, which is in supersession of all the other earlier procedures. I'll just give you a small insight about how it functions, just in 3-4 steps, so that how it's done actually. So in the event you actually have to file a petition or an application before the court, your advocate on record will have to first file the petition or application through the e-filing portal, which is available in the Supreme Court's website. Thereafter, the petition will be scrutinized by the registry for defects, etc. So, once such defect is marked, you will have to then clear the defect and that you otherwise would have ordinarily done in a regular filing, and refile your petition again, upload your petition rather online. Once this is done, then the registry, lists the matter in on a certain date for coming up before the court. And before the actual hearing takes place, the registry will send you the link for the virtual hearing. Your advocate on record, sometimes it's not that the advocate on record will only appear himself. There may be the party or the client or the his brief or his engaging advocates might want that a senior counsel appears. So you will have to then give. What happens is technically the Supreme Court creates a WhatsApp group one day before the hearing. So in that WhatsApp group, they'll send you the link and they'll ask you who all are going to appear alongside you. So you give the names so that on the next day, when people click on that link and enter, they are easily granted access, etc. And so this is how you click on the link and you appear when your matter comes up on the date of its listing. So yes, then basically, regardless of the circumstances, the Supreme Court just does not cease to function, and it has been discharging its duties much as it was like it was doing before the COVID era. So yeah, with that, I basically have come to the end of my talk in this webinar, and it'd be great. I hope you guys liked it, and let's see if you have any questions, and I'm try to answer.
All right, sir. So, sir, actually, we don't have very substantive questions, but yes, we have a
Yeah,
lot of questions.
no problem.
If
No
you
problem.
want, I can proceed towards it.
Yeah, surely, please, please
All
go
right,
ahead.
sir. So the first question comes from Vasudha Priyancha, and she wants to ask, how can we start practicing in Supreme Court, and do we have to clear any specific examination for it?
So yeah, Vasudha, I'll tell you, practicing in the Supreme Court and being able to file in the Supreme Court are two different things. I'll tell you. So when I started off my career, I also was I had joined the chambers of a certain counsel who had a lot of practice in the Supreme Court. So for all practical purposes, drafting of SLPs or civil appeals which came across our way, briefing counsels, briefing my own senior, briefing senior counsels, otherwise, etc., was all something which was available to me as a practicing counsel. So, so basically, practicing before the Supreme Court will not be a bar for you. What you will not be able to do is file a matter for your client directly. For that, you will have to pass the advocate on record exam. So, an advocate on record exam is you are eligible to sit for once you firstly finish 4 years, if I remember correctly, 4 years, and then it has to be followed by 1 year of training with an advocate on record who has a standing of 10 years. Basically, she or he or to have passed the advocate on record exams and practice for 10 years as an advocate on record, she or he would have to take you under his tutelage for 1 whole year. So totally you cross 5 years, and then you can file your form in the Supreme Court for sitting on in the exams. Once you clear it, and it's not a very I would not say it's a very difficult exam, but it is slightly it's one of those exams which requires your time. There are exceptional candidates, of course, who maybe very smart and can clear it without much preparation. I had to put in a lot of hard work. I know that. So yeah, it takes some because when you're practicing also to take out time to read so many case laws, etc. It takes some time. You have to pass that exam, and you are then eligible to file as well. So you can do that. But there's no bar for you to practice in the Supreme Court from the moment you pass. There's one thing. Sorry, I must mention which I skipped my mind. I'm not very sure as of now, but probably for if you have until 1 years of practice, you may not be allowed to argue before the court. My memory is not serving me very well right now. I'm sorry about that, but I think there's some sort of a problem with that. That for 1 year you may not be able to argue directly or mention before the court directly.
All right, sir. So moving on towards the next question. The question comes from Ranjit Biswas, and he wants to ask whether there is any special provision to file a fresh suit in the Supreme Court instead of appeal cases.
Okay. Now, one thing if Ranjit would write again, that would be more clear. But see, a suit can be instituted in the Supreme Court, which I mentioned, but a private party suit is not entertained in the Supreme Court. Suits only in the nature of what is mentioned in Article 131 of the Constitution. That is between the central government or on one side and the state government, or one or more states on the other side, central government or state government together on one side, one or more states together, or a single state on the other side, or one state against the other state. Those are the only three types of situations where an original suit can be instituted before the Supreme Court. Article 131, if you just take a note of that, you will get to know.
All right, sir. So moving on towards the next question, sir.
Yeah.
Sunny Kumar wants to ask, sir, can you tell us how to file a PIL in Supreme Court?
Yeah, surely. So there is the PIL is basically again another extraordinary jurisdiction of the court. See, ultimately it's registered as the writ petition and within brackets PIL. So it is basic because of the fact that it is something which is to do with your fundamental rights. So Article 32 definitely comes into place, but it's a PIL because it is in interest of the public at large. Now, the process of filing it is similar to that of an ordinary writ petition. It's just that a PIL has certain very important, how do I put it to you, conditions that you have to fulfill. Basically, there are certain very important stipulations that have to be made while filing a PIL. That is, for example, firstly, your credentials, who you are, and why have you filed this PIL. You have to give an undertaking that you have not filed this PIL for a personal benefit, that you have no inherent interest in the outcome of this PIL. And so those stipulations have to be properly stated in your PIL. And after that, it is just like any other writ petition that you may have otherwise filed before the Supreme Court. There is also a situation. So sorry, I'll just inform about it. There is also a situation of or letters PIL that you can file, which are accepted by the court. In situations, you may have also come across these sort of cases in your case laws that you have read. You may write to the registry of the Supreme Court, and the Supreme Court can take cognizance of such letters and convert them suo motu into public interest litigations.
All right, sir. So as you mentioned earlier that Supreme Courts have not, it has not stopped working during this pandemic, and it is
Right.
continuing it through virtual process.
Right.
So Shara Rajora wants to ask that what security and precautions has the Apex Court taken to protect the exchange of information and data that is being recorded in the present form of virtual proceedings?
Okay, see, that is a very technical question, all right? And I do not know how apt aptly suited I am to answer that question of data protection. See, one is, I'll tell you this. As far as filing is concerned, as advocates on record, we have our own code. So when we file a certain petition, I go to the portal of the Supreme Court. I log in through my own credentials, upload the document. Now that is available for viewing only to me and the registry of the Supreme Court. In that way, I can say that, for example, a third party who is not supposed to know about the contents of my matter will definitely not have access to it unless he is a party to the case. Therefore, I would have to necessarily share. Now, the second part is on in when virtual hearings are going on. Now, if the question has anything to do with security when hearings are going on, I really am not in a position to answer that bit. But as far as documents confidentiality is concerned, what you file, that is not an open forum that you can simply file and if people have access to. You do it through the portal of the Supreme Court by logging in through your own credentials, and that is how I think the security is maintained.
As I have also witnessed, that many advocates and lawyers actually come up to the platform of LinkedIn and other social medias, forwarding it that few advocates are doing that. They are taking screenshots and pictures of the virtual proceedings and posting it online. So condemning it and telling it that it's not correct and it's not moral according to the provisions of the code. So with that, coming on to the next question. Minakshi Raj wants to ask, so what is your take on the collegium system of appointment of judges of Supreme Court and High Court, which is not transparent?
See, I have a very conservative view on this, and I'll tell you where I come from. There's a lot of I mean, there's a good amount of view, and every view is welcome, right? We are not. I mean, we're a democratic society, so it's not anybody's views against mine. Everybody's views are welcome. I have a conservative view that I actually am in favor of the collegium system. See, there have been a lot of proponents, very learned people who talk about why the collegium system is not good because it's not transparent and the judges are appointing themselves, and we really do not know the criteria of appointment. Maybe is what they state, and what the alternative approach is. When the NJAC came about, you had somebody from the government, you had somebody who was almost like an elderman, or somebody a known person in the civil society who would also be a part of it and would sort of to go about with the checks and balances processes. But I have a very different feeling. I feel that the separation of powers is a very important facet that we should be able to maintain. The separation of the executive and the legislature from the judiciary is very important, and therefore any sort of legislative interference in the process in whatever little manner, in my opinion, can become a big problem. I feel that the Honorable Supreme Court should be a fearless court, which it is till now. It's a court which can take on. It cannot be a friend of the government. It cannot. It will not be. It doesn't mean to suggest that I'm saying that it should pull up the government for things which for anything which it thinks is in its view maybe, or the view of the petitioner who may have filed something against the government is not correct. I'm not saying that, but it should be able to pull up the government also when it sees that what the action with the actions that they may have done is not correct. So, in a situation such as that, if we have a judiciary which is where the judges are selected in the collegium system, it sort of bars that interference from the legislature and the executive. And the transparency situation that we are talking about, it is not that it's completely not transparent. I mean, you have to call for records of the judges. There are IB reports given of the people that you are trying to appoint as judges. You are sending the reference to the government. The government has a right also to say no. But the Supreme Court has the ultimate right that if they feel that the rejection that the government is making of a certain judge, the Supreme Court thinks proper to be appointed, then the Supreme Court then deems it, then can take that last call, which I think is fair to maintain the separation of powers. So slightly conservative, do not mind, but yeah, that's what I feel.
Okay, so very well said, sir. Coming out to the next question, sir, Shubham Mehra wants to ask, so what is the difference between a PIL and an SIL, that is social action litigation?
Okay, I do not know if this terminology is used by the registry of the Supreme Court. And I can state probably with some certainty that this may not be a term that is used while filing of a case. It is mostly a term which is basically how we differentiate two different types of cases. Could you just say social?
Social action litigation.
Okay, so I mean, I'm only speculating here. That, of course, a public interest litigation, as the name suggests, is for the interest of the public at large, and it could be for anything. For example, we have a case going on in the Supreme Court now in relation to refund of airfare, for example. So that may not be something which is a social action litigation per se, not something to do with the environment, or poverty, but concerns everybody, all the masses in general. That if your flight wasn't did not take off owing to COVID, then you must get your refund of your airfare. That is how I'll distinguish it. But I'm extremely sorry that I'm not being able to give any very direct answer on this particular point.
Okay, sir. So, sir, actually, many people are asking about the advocates on record thing, but as you have already answered it, so I think people can just look at the recorded session and look for the answers. But can you suggest some books as asked by Clint Climaco?
Right?
He actually wants to know about some books that you can refer in order to know more about the AOR exams and how to clear it.
Yeah, I'll tell you. See, there are four papers particularly. Firstly, there are four papers that you hear. One is this, what we are talking about today, practice and procedure. It's a very elaborate topic. It's not something that which I could have really covered today fully in the session. So I give you a little flavor of it. You have practice and procedure is one paper. You have leading cases, which is one paper. You have professional ethics, that is one paper, and the last paper is drafting. So, as far as practice and procedure is concerned, see, you will have to first read the Supreme Court Rules 2013 itself to know in and out about what the procedure is. Uh, I mean, you don't have to really mug things in book, but you should know that there are these many orders in the Supreme Court. These orders, order one says this, order two says that, etc. So the Supreme Court rules are give you a good starting point in relation to practice and procedure in terms of what it contains. But to understand how the procedure is developed, one very good book is Practice and Procedure by Senior Advocate Mr. Raju Ramalingam. Brilliant book, and that is I don't I think it has gone out of production. But when I got it, I think you get in the Supreme Court's library, or there's a photocopy shop which is in that in the underpass to Supreme Court when you go from ILI side, etc. There's this photocopy shop or a bookshop which also sells this photocopied material. This you will get this over there by Mr. Raju Ramalingam. So this is one book I can prescribe on practice and procedure. Then leading cases is something which you'll have to go through fully. You'll get a list of it when you sit for your exams. When you are ready to sit for your exams, the Advocate on Record Association will come out with the list of leading cases which you need to take care of. We also have classes before these exams taken by the senior counsels, by distinguished senior counsels, where because of the fact that it's such a huge paper and so many leading cases are there, they tell you a bit about the areas where you might want to concentrate. So you have to be a little smart and take a cue from there and prepare on those lines. So that would be for leading cases. You definitely I did that, so I'd suggest this. Just read everything that's provided over there in that list. As far as the paper of ethics is concerned, the Supreme Court, if you go to the Supreme Court website even today and you go to the AOR section, you'll find these past papers, and along with the past papers, there are a lot of these reading material on ethics, professional ethics and advocacy. Very very brilliant articles, which we should generally follow in life, basically. So if somebody is ethical about their practice, and this paper comes very naturally to you. You have to, when you read the articles, you will know that all that is telling you, is to be a conscionable lawyer, be ethical about your practice, not do things which puts the profession itself in disrepute. So as far as this is concerned, a professional ethics paper is concerned, you can go to the Supreme Court's website, to the AOR section, and see past papers and the articles on professional ethics. Last is drafting. So this is not something you need a book for. You will have to ask your seniors or mentors and friends who are already in the practice for drafts. But the thing is that you will have to you have to really practice this, because it's a very long paper. So you will have to see these past papers, see the sort of questions that they give, so that you know that in what time you are being able to turn around, with a draft. You'll have to probably attempt at least 4 questions in the drafting. You'll have to draft an SLP, you'll have to draft maybe a writ petition, an application, or sometimes only a counter affidavit. So you'll have to know, like, the form and content, what I told you today about in the writ petition. You'll have to, in the special leave petition, you'll have to know all of that. Your draft has to fully fit that. So you'll have to know the formats properly of the drafts, what has to be there where, and accordingly keep fitting your necessary pleadings there.
All right, sir. So, sir, actually, there is a topic that I actually wanted to put forward in this session and ask your opinion on it. Sir, actually, the government has actually come up with a bill that is EIA, Environmental Impact Assessment Bill. I think so. Can you throw some light on it, and can you tell us, like, what are your opinions on that?
No, okay. Now you've actually caught me in a quandary here, because owing to the sort of practice that I am in, mostly on the commercial domain side, I have, to tell you very honestly, not gone through the bill. I have only gone through the report per se, which is available in public domain on reading of news. But one very important thing which I can talk about is that what it does is it makes clearances of projects also very easier. But the comment which is coming from the environmental association side, if I may put it that way, is that how much safeguarding is there in relation to these clearances that are being sought, may be an issue. So I have only that much knowledge as of now, to tell you very honestly. I'm so sorry that I cannot throw much light, but this is what my knowledge as of now on the bill is that.
Okay, sir, it's completely fine, sir. Sir, as a last question, actually, sir, I want to put up in front of you is, as you have also you are an advocates on record working in Supreme Court, and you also are a partner at this Diwanji. So, sir, you have experience corporate and litigative side of the
Hemant, I'm so sorry. I just lost you for about 5-6 seconds there. There was some sort of a.
Okay, sir.
Yeah.
Yes, sir.
No problem. Please tell me.
Sir,
Yeah, absolutely.
Is it fine now?
I hear you.
Okay, sir. So, sir, I was saying that to the people like who are about to get graduated, or who are in their first to fourth year of law school. So, sir, this generation, talking about obviously my generation and people who are my colleagues and who are my batchmates. So, people have different connotations of different legal aspects. So, what do you think? Is it the same way the people pursue it as, like, they are more into series like Suits and all, which have given a perception of how a legal fraternity looks like in corporate world and in litigative world. So how can you comment on that, sir?
Okay. Firstly, we really cannot compare ourselves, to the series that we see on TV, particularly the ones which are from abroad.
broad, which is very slick and it looks very fancy. As far as the corporate side is concerned, one thing I would like to clarify, although I work in a typical business firm situation, but I do litigation. So, but of course, I see a lot of the corporate work being done by my colleagues. So, the corporate practice still looks a lot fancy. I mean, because you are really very, you're dressed very poshly, and okay, I shouldn't say that. I mean, not trying to Delhi courts, etc. is amazing. So litigation in India also is a very potentially I mean, how do I put it? It's a place which offers a lot of potential for success for anybody who is really interested in pursuing litigation. Because of course the corporate side of it is very monetarily rewarding from the very first instance. But if you have patience, the litigation part is also very rewarding and is a very interesting area to actually practice.
All right, sir. So, sir, can you please give our viewers a final piece of advice, considering that most of the people who are watching us today are law students only? So, what will be your final piece of advice to them, sir?
Yeah, surely. See, technically, I have not reached a position that I can really advise you across the spectrum, but I'll tell you my two bits from the point of view of the fact that I have come across from a situation where I was exactly like you all. I mean, I'm not saying having a lawyer background is anything wrong. It's people who come from law backgrounds also. I mean, family law backgrounds also have to really strive hard, but more often than not, we have a lot of colleagues who do not come from law family backgrounds, and the striving or the work, maybe the amount of effort that you have to put can be a little more at that. But the fact is this: when I did my law, I really did not have a clue about the practice. I did my law from Delhi University. I was at the Hindu College where I did my political science bachelor's, and once I finished my political science, I thought, what is it that I would do next? And I ended up doing law just because some other friends also were doing law, probably. But probably this was a calling. I don't know. Once I was at a law college, even then it was not a situation where I was really, very smart, or that I would be understanding or interning like most of you guys do. But what it ultimately requires, which I have realized now that I have finished about 12 years in practice, is that you just have to stick around. When you first enter the profession, everything can be a little hazy. You may not know everything. You definitely would not know everything. You just have to keep your senses out, open, be observant, take notes, listen to your seniors. Sometimes they may be a little tough. Take it on your stride, because probably, I'm sure mostly there will be nothing personal in that, and it will be only because they're trying to mentor you. Read a lot, because there is no exception to it. We can't. This is one place where it's a professional life, right? You can't make a mistake. The scope of error has to be zero. When you draft, or when you plead your case before court, your preparation cannot be shoddy. You have to be ready, like you are for like you have to be every day ready, like it's your final arguments, and the entire case rests on what your preparation is about. So whatever I'm saying, I know it's a bit of a cliche, but cliches are often the most accurate things, are often always stated. So can't help it. So, and if you're at it and you are dedicated, you are not lying to yourself, you are honest to yourself, rather, on a positive note about the brief that is given to you, you will just very nicely enjoy your time. Time will just pass. You will not know. You'll reach a certain level. Somebody asks you for an opinion. You are immediately ready. You said, "Oh, this has happened." No, don't worry. This is how we look at it. A complicated situation presents itself to you. You will have no qualms addressing it. So, of course, experience is what it comes. Basically, it will develop over time. All that you need to do is, be at it.
All right, sir. So with that, sir, I can say that we have come to an end of this wonderful session. And I must say that it was a pleasure indeed listening to you, sir. And in spite of having such a busy schedule, you managed to spare this time for us. Actually means a lot to us, sir. And on the behalf of whole team of Legal Sarcasm and Spread Law, I would like to thank you for being here and enlightening us, sir.
No, the pleasure was all mine. I'm to tell you honestly, Hemant, this was such a. I'm so sorry that I cannot really, see all the other viewers. But that's how it is. That doesn't matter. But I'm thankful to all your viewers through you and your team for sparing time to participate in this webinar that we had today. I had a great time. I hope I was able to contribute something. Maybe it was enriching in some way for the things I could not answer. I'm sorry about that. But hopefully we had a good. I had a very good time. Hope you had yourself.
Surely, sir. Surely. To the viewers, I know many of the people must be aware of that. We have come up with a concept of a new constitutional law tournament. So do feel free to participate and inquire about it. And I personally assure it to be the best of quality provided. So the links are in the description. So do check it out. And rest. So thanks a lot for being here. And thanks everyone for being so participative and interactive. Thank you, ma'am. Thank you, sir. And thank you, everyone.
Thank you, Hemant. Thanks so much. Thank you to your team also. Okay. Bye.